So with this, I'll get to the last part of my talk, which is regarding enforcement of patents and where exactly you can, or what exactly you do when you enforce your patent. Now, whenever there is any proof of infringement in the hands of a patentee, they can file a suit for infringement. Now, the suit for infringement can be instituted. The lowest level court in this case is going to be a district court or a high court. So there are at least six high courts which have original jurisdictions, civil jurisdictions for entertaining patent lawsuits. These are the high courts in Delhi, Bombay, Calcutta, Madras, Jammu and Kashmir, and Himachal Pradesh. So you can file infringement suits in before either the district court or the high court. And if, however, as a defense to your infringement suit, the defendant files a counter claim for invalidity of your patent. अगर defendant कहता है कि ये suit valid नहीं है क्योंकि इनका patent ही valid नहीं है, which is a counter claim for invalidity, तो if such a suit has been filed before the district court, it will have to be transferred to the high court. It cannot stay before the district court. So in case there is an invalidity or a challenge to the validity of the patent, the suit has to be transferred to the high court. Now, there has been this Commercial Courts Act, the introduction of the Commercial Courts Act in 2015, through which certain changes have been made in the scenario. And now it's not like any district court can entertain a patent lawsuit, particularly if the high court under whose jurisdiction the district court is has a commercial court division, then you cannot file a lawsuit in a district court, a patent infringement lawsuit in a district court. So, for example, in Delhi, we have a commercial court division in the Delhi High Court. तो अब आप दिल्ली डिस्ट्रिक्ट कोर्ट में नहीं फाइल करेंगे, दिल्ली के डिस्ट्रिक्ट कोर्ट्स में नहीं फाइल करेंगे, आप हाई कोर्ट में infringement suit file करेंगे. Now, what is the burden of proof in filing an infringement suit? The burden of proof is split. If it is a product patent, अगर आपका patent product पर है, तो burden of proof to establish infringement is on the party alleging infringement, that is the patentee or the plaintiff. तो plaintiff establish करेगा कि defendant का product जो है वो infringe करता है उनके patent को. पर अगर जो patented subject है वो एक process है, if it is a process, then the burden of proof shifts. The burden of proof shifts on the defendant, provided that the patentee shows that the subject matter of the patent is a process which is resulting in a new product, or that there's a substantial likelihood that an identical process has been made by the patented process and the patentee has been unsuccessful in spite of reasonable efforts to determine which process was used to prepare the product. So, अगर patentee दिखा देता है कि there is a substantial likelihood कि जो product defendant का product है जो बिल्कुल उनके product की तरह है, वो patented process से ही बना है और उन्होंने बहुत कोशिश करी जानने के लिए कि कैसे product process से बना है पर उनको नहीं पता चल पाया, then the burden of proof shifts on the defendant to establish that the process that they are using is different from the process that the patentee is claiming to be patented. Now, what are the defenses in the case of infringement suits? The defenses in infringement suits are defined by Section 107 of the Patents Act. And सबसे पहला defense ये है कि आप बोलें कि जो patentee का the patent है वो valid ही नहीं है. So that is a counterclaim for invalidity of the patent. या फिर there are certain acts which do not amount to infringement. For example, अगर आपने patented product या process को experiments में use किया, research में use किया, या teaching purposes के लिए use किया, for imparting instructions to pupil, then it is not an infringement. अगर government use के लिए था, आपका जो भी आपका use था, that was in pursuance to orders of the government or in pursuance to directions from the government, then again it is a defense to infringement. Other than this, there are certain acts which are not considered infringement, and these are provided by Section 107A of the Patents Act. The first provision is the Bowler provision. Bowler provision means any act of making, using, or selling it or importing a patented invention solely for the purpose of developing information which is required under any law for the time being in force, that regulates the manufacture, construction, use or sale or import of any product. So basically, for example, इसके लिए सबसे common example होता है medicines का, जहाँ पे एक patent है which exists on a medicine, and there are several generic manufacturers who are looking at launching the product in the market once the patent expires. पर जेनेरिक मैन्युफैक्चरर भी सीधा अपनी मेडिसिन को लेके मार्केट में कूद नहीं सकता है, उसको कुछ अप्रूवल्स की जरूरत है, तो वो पैटेंटेड प्रोडक्ट को यूज कर सकता है फॉर डेवलपिंग इंफॉर्मेशन टू गेट रेगुलेटरी अप्रूवल्स. दिस इज द बोलर एग्जेम्पशन. That kind of use is allowed or is permissible under the law, and this will not be treated as infringement. If you have used the patented product or process to arrive at a product, to gain information and to obtain approvals under any law for the time being in force in India, that will not be treated as an infringement. Then there is another provision which is called as parallel import. Parallel importation is based on the principle of exhaustion of rights. So basically, parallel importation is where you are importing a patented product into the country from a person who is authorized to sell. मतलब कि जैसे इंडिया में एक कंपनी ए किसी ड्रग को 100 रुपए में बेच रही है, पर बांग्लादेश में वही सेम कंपनी ए जो कि पैटेंट होल्डर है उस ड्रग को 50 रुपए में बेच रही है. नाउ आई वांट टू, कोई इंडिया में पार्टी है बी, वो बांग्लादेश में उस ड्रग को खरीदती है from the patentee and imports it into India and sells it at 70 rupees. तो पैटेंट होल्डर ये नहीं कह सकता कि उसके राइट्स इन्फ्रिंज हुए. क्यों? क्योंकि इस पर्सन बी ने सबसे पहले पैटेंट होल्डर से ही वो ड्रग बांग्लादेश में खरीदी. So there's exhaustion of rights. Patent holder has already sold the product to the importer. They have already sold the product to the importer at a lower price in Bangladesh. Once you have sold your products, you do not have any rights over those products. You've already claimed whatever rights you had in that product by selling it over. Now the importer can sell it off at any price in India. So this is the principle of parallel import, and it is based on the principle of exhaustion of rights. And doing something like this, where you are importing from a person who's authorized to sell the patented invention, will not amount to an infringement. So this is section 107A of the Patent Act. What are the reliefs that you can get in case you are able to prove an infringement? In case a patentee is able to prove an infringement, the first relief is, of course, an injunction. The offending party will be injuncted from carrying out the offending acts. And at the option of the plaintiff, you can either get a damage or an account of profits. You can get damages or accounts of profits. You could even get costs. And the court could also order a seizure or forfeiting or destruction of infringing goods or any substance or implements that are being used for the production of infringing goods. So with that, I end my talk here. Hemant, if you have any questions.